Hi, my name is Ahmed Azan Akbar and my University of Hertfordshire student ID is 240-59610. In this video, I will be advising Suleiman, the owner of Haveli restaurant, on his rights and remedies under the Sale of Goods Act 1979, also known as SGA. We will explore how the law protects buyer when goods are not according to order, damaged, out of order, not fit for use, of poor quality, etc. And what remedies are available for buyer Salman against the seller Amjad Furniture Store and their sale advisor Saman. Let's start with the background. Sulaiman visited the Amjad Furniture Store and met Saman, a sale advisor. He made a purchase on her advice and signed the contract of purchase of following goods, which will be delivered on 17th of September. 25 large grey marble tables, 100 minor wear and tear polished velvet dining chairs, and one leather sofa set. On 17th of September, following goods are delivered: 10 medium-sized marble tables, 9 wooden tables, 1 extra large marble table in grey, 100 defective chairs packed in the box. In view of above, Suleiman contacted Amjad's Furniture Store and told that he is going to return the goods due to following reasons. The quantity of marble tables is short and also not according to order. The chairs were greasy, which is major defect and cannot be used. The leather sofa affected the health of his daughter, and this concern was showed to Saman, and she ensured that nothing will be happen regarding health. When he called to reject everything, Saman told him it was too late. He had to accept and pay. The act of the Act of Amjad Furniture Store raises several issues under the Sale of Goods Act 1979, which are as under: sale by description, satisfactory quality, fitness for purpose, delivery and acceptance, remedies and exclusion. Sales best. Let's start with sale by description. Section 13. Under Section 13, when goods are sold by description, they must correspond with that description. Here, Suleiman placed the order of extra large grey marble tables but got mostly wooden and medium size ones, which is breach of contract. In Varley vs. Whip 1900, the court held that a buyer could reject goods that didn't match their description. Similarly, in Arcos Limited, Ronasan 1933, even a small difference justifies rejection. So Amjad Furniture Store breached the contract and violated the Section 13 of the Act. The tables which were mentioned in contract don't match the table delivered. Satisfactory quality. Section 14, subsection 2. According to Section 14, subsection 2, the goods sold in the course of business must be of satisfactory quality, meaning thereby the goods sold must be the same as customer selects, which were mentioned in the contract. According to Section 14, subsection 2b, goods ordered should be good quality, appearance were excellent, finishing must be fine, not be defective and durable. Someone said the X-display chairs in good condition apart from minor wear, but the chairs affected by grease marks and scuffs which go beyond minor wear. So the chairs are not of satisfactory quality. In Roger vs. Parrish Limited 1987, a Range Rover with small defects was still rejected because it didn't meet reasonable expectations. Likewise, Bernstein vs. Pemson Motors 1987 showed that even minor issues can breach this duty, so that Suleiman may reject the order of the chairs under Section 14 subsection 2, and same reasons are applied on whole order. Fitness for purpose. Section 14 subsection 3. According to Section 14 subsection 3, if a buyer tells the seller the specific purpose of the goods and relies on the seller's skill, the goods must be fit for that purpose. Suleiman asked from someone that leather sofa would irritate people with skin condition, wherein someone assured him it wouldn't. That was clear communication and alliance between them. But when Suleiman's daughter sits on the sofa and begins itch and she develops a red blotchy rash on her body through the night, which was a clear violation of Section 14 subsection 3. So that Suleiman have right to breach the contract. In Griffiths vs. Peter Conway Limited 1939, the buyer failed because she didn't disclose her sensitive skin. Here Suleiman did it, so the store can't force him to accept the order and pay the amount of order. The test from Jason Limited vs. Bohan 2003 communication lines and unfitness is fully satisfied. Delivery Section 30 and acceptance Section 35. According to Section 30 of the Act, where the seller delivers to the buyer a quantity of goods less than he contracted to sell, the buyer may reject them. Sulaiman received less quantity as compared to order of goods which were also different size and making as well, which causes breach of contract under Section 30 subsection 1. Acceptance is defined under Section 35 subsection 1. A buyer is also deemed to accept goods where goods are delivered to the buyer and he has not previously examined them. He is not deemed to have accepted them under subsection 1 above until he has had a reasonable opportunity of examining them for the purpose A of ascertaining whether they are in conformity with the contract, and B, in the case of contract for sale by sample, of comparing the bulk with the sample. Sulaiman only opened one box and raised a complaint immediately. He used his rights and early stage by random checking of box packed goods, which means that Sulaiman only checked the goods, not used them, and accepted is not completed. So Sulaiman can rightfully reject delivery of goods. In Clegg versus Ole Anderson, 2003, the Court of Appeal said a buyer could still reject goods after some time if they hadn't clearly accepted them. Remedies and exclusion clauses. On the basis of aforesaid reason, Sulaiman breached the contract under Section 13, Section 14, subsection 2, and Section 14, subsection 3. Sulaiman used his right to breach the contract and rejected the order of all goods and also have right to claim damages. If Amjad Furniture Store relies on an exclusion clause like no refunds on ex-display goods, that's restricted by the UCTA Unfair Contract Terms Act 1977. Under Section 6 UCTA, a sellers can't exclude liability for breach of Section 13 and 15 SGA unless the clause is reasonable, which it's unlikely to be here. Also, for an exclusion clause to apply, it must be properly incorporated into the contract before or at the time of agreement. In Ole versus Marlborough Court 1949, a hotel notice wasn't valid because it was shown after the contract was made. And in L. Strange versus Gorokov 1934, the court held that signature normally binds but only if the clause is clearly presented. Someone never mentioned any exclusion, so the store can't avail any benefit on it. Conclusion and advice. On the basis of foregoing, my conclusion and advice to Sulaiman are as under. Sales by description Section 13 subsection 1 says that where there is a contract for the sale of goods by description, there is an implied that the goods will correspond with the description. Here the tables were not same description with the order one. Therefore, Sulaiman can reject them and breach the contract. Fitness for purpose. Section 14 subsection 1 said that except as provided by this section and Section 15 below and subject to any other enactment, there is no implied about the quality or fitness for any particular purpose of goods supplied under a contract of sale. The agent of Amjad Furniture Store, Sanam, gave assurance that leather of sofa will the fine quality and harmful for any and not harmful for any human. When leather of sofa affected Sulaiman's daughter, he has a right to breach the contract. Satisfactory quality. Section 14 subsection 2. According to Section 14 subsection 2, where the seller sells the good in the course of business, there is an implied term that the goods supplied under the contract are of satisfactory quality. Whereas in this case the chairs were defected, so it gives the right to reject the order. Section 30 and 35, delivery and acceptance. According to these section, delivery of order with wrong quantity and the type gives the right to buyer that he may refuse to accept the goods, and Sulaiman reject the order as well as the breach the contract. This concludes my advice to Sulaiman. Thank you for listening.